Good afternoon, ladies and gentlemen. The webinar is beginning. Welcome. My name is Chris Wilson. I'm the Communications Director here at the Dallas-Fort Worth Hospital Council. Thank you for being here today for this educational webinar hosted in coordination with Polsinelli, an associate member of the Council. Normally, our President CEO, Steve Love, would serve as host of our monthly webinars, but he was called to Washington, D.C. to work with the American Hospital Association. So he sends his apologies. Today's topic is data analytics, how prosecutors use billing data and why. This is a great topic and we have a nice turnout today. Today we will discuss the data analytics used by the CMS to investigate billing irregularities and make referrals to the Department of Justice. Our speakers will also address investigative red flags and explore how referrals are made to the Department of Justice and how hospitals should respond. Today's speakers are Adrienne Frazier, a shareholder at Polsinelli, and Erin, Thimmesch, an associate at Polsinelli. We are looking forward to their presentation. And before we begin, please note we will be taking your questions. If you could type them into the question box, we will answer them before the end of the presentation. Without further ado, ladies and gentlemen, here's Adrienne Frazier.
Good afternoon, and thank you, Chris. I, along with Erin Thimmesch, are so excited to present to you on data analytics, how prosecutors use data and why. As Chris mentioned, my name is Adrienne Frazier. I'm a shareholder in the Dallas office. I'm in the government investigations group with an emphasis on healthcare. Prior to my time with Polsinelli, I was with the Department of Justice for 10 years, all through that time prosecuting healthcare fraud. Erin?
Hi everyone, I'm Erin Thimmesch. I sit in our St. Louis office. I'm in our healthcare operations group and I advise healthcare clients, primarily hospitals and pharmacies, on compliance issues. Oftentimes that's in the course of internal investigations or investigations by DEA or DOJ. I specialize in matters that involve significant data analysis, which is increasingly common for healthcare providers, as we'll discuss today. Happy to be here with y'all.
We're going to start with just a little bit of an overview about what we're going to cover here today. So first we're going to cover data analysis kind of in the building of investigations. Then we're going to go through several recent case examples that have been prosecuted by the Department of Justice. These are cases where data started the investigation and maybe was used in some way throughout the investigation and prosecution. And then after that, we're going to talk through compliance tips for your organization and ways to use your own internal data to proactively combat kind of some of the issues that we're seeing in some of these cases and make sure that your organization, never runs into investigators. So let's start with the Department of Justice's Healthcare Fraud Unit, because this is the #1 entity that really uses data analytics in building and developing its cases. So the criminal division of the fraud section at the Department of Justice has a healthcare fraud unit. It has 80 prosecutors. They prosecute primarily criminal matters. However, sometimes there's a little bit of an overlap between cases that are maybe running on a civil track, maybe also in tandem with a criminal case. But like I said, 80 prosecutors throughout the nation in 16 different cities. And their mandate in starting the healthcare fraud unit was to base their investigations on data analytics in order to allow them to prosecute recent and ongoing cases, because those are kind of the ones with the best evidence. If something is ongoing, it's easier for them to kind of target that and use their traditional investigative methods to develop those cases. So this quote comes from the Healthcare Fraud Unit. It says the Healthcare Fraud Unit is a leader in using advanced data analytics and algorithmic methods to identify newly emerging healthcare fraud schemes and to target the most egregious fraudsters. The Healthcare Fraud Unit's team of dedicated data analysts work with prosecutors to identify, investigate, prosecute cases using data analytics. This novel approach has led to some of the fraud section's largest cases and initiatives. If you have heard of the annual takedown, you're familiar with the healthcare fraud's use of data and moving these cases quickly and charging kind of a large number of providers, or not just providers, a lot of other individuals in these schemes too. And one thing I want to point out about this is that the Healthcare Fraud Unit has its own group of data analysts that sit in the same offices with the prosecutors. So they directly take the data analysis and provide it to prosecutors to develop their cases, really without the use of investigators. It's kind of a very seamless approach to building cases. They also allow those data analysts to help U.S. attorneys' offices build their cases as well. All right, so when we talk about investigations versus prosecutions, because they're not the same, some investigations don't result in any kind of prosecution or any kind of charge or complaint filed. But you may be familiar with the different investigating agencies such as Health and Human Services, Office of Inspector General. They generally prosecute and, investigate Medicare. Next is the Medicaid Fraud Control Unit, which investigates Medicaid. And then the FBI, of course, has kind of full jurisdiction to investigate Medicaid fraud, Medicare fraud, and also private pay. So they really kind of reach into all those different realms. There are some other agencies that also have a nexus to federal programs that you wouldn't really think of would prosecute healthcare fraud, but they are some of the best investigators truly working these cases, and that would be like the Postal Service. They have a nexus to the Department of Labor claims. So like when their employees have a workers' compensation claim and there's maybe some tie to a fraud scheme, then Postal can come in to inspect or to investigate. The IRS, if there's any kind of tax allegations. I've also mentioned Department of Labor. There's also some really unique agencies that you wouldn't think of, such as like the Railroad Retirement Board, that whenever they have a beneficiary of their retirement services who is also a Medicare beneficiary, and that Medicare beneficiary's information has been used in a scheme, then Railroad Retirement Board of all agencies can come in and investigate. And then on the prosecuting side, we've got the Department of Justice, which, as I mentioned, has a healthcare fraud unit in DC and in several cities throughout the nation. There's also U.S. attorneys' offices in each state, depending on how many districts they have. In Texas, we have 4 different districts. Dallas sits in the Northern District of Texas. And then when we're looking at state offenses, which would be Medicaid, the district attorney's offices prosecute those. Of course, we've got Dallas County, Tarrant County, Collin County, some of those other smaller counties too, but they likely wouldn't prosecute their own cases. They would bring in like the Texas Attorney General to kind of work those. And just a point on this too, the U.S. Department of Justice, although they've got their criminal division healthcare fraud unit, the U.S. attorney's offices and the civil division of the Department of Justice also bring civil cases too. So False Claims Act violations, they run their own investigations, like I mentioned earlier, sometimes in tandem with the criminal investigators, sometimes, on their own track. And so kind of continuing along this path of how investigations are built, when we talk about the collection and review of data, we are talking about like Medicare data, Medicare billing data, Medicaid billing data, private pay data, although to a lesser degree because federal investigators just don't have as direct of access to that type of data. And then also like PDMP data, kind of all the sources that investigators can pull from in order to compare and contrast providers amongst their peer groups and to look at trends in the data. So that would be, in these types of investigations, these data-driven investigations, the collection and review of that billing data is going to be the first step. Next step is going to be kind of more traditional document requests, so like patient files, maybe internal communications from an organization to corroborate what they're seeing in the data. And then finally, financial information subpoenaed from banks, maybe some type of information just given voluntarily via providers. That's kind of that last step in the document requests. And then the next step would be to take that data and kind of what they're seeing together and conduct witness interviews. And that's going to be generally former employees of a entity, maybe patients, maybe current employees. And the goal there is to kind of either corroborate what they've seen in the data or to dispute what they've seen in the data, right? To finish out the investigation and make sure they're on the right track. And looking at this billing data in terms of how the different entities are able to obtain it. So on the one side, you've got Medicare, which through their Medicare contractors, their UPICs, are able to look at the data. They're able to mine the data. They have it in real time, so it's kind of immediate. They can take a look at that and determine whether they're seeing any billing irregularities or any overt cases of fraud. On the Medicare side, the contractors, they're going to then take that information and decide what the next steps are. So potentially the next steps are to continue to investigate through the UPIC, so maybe do beneficiary interviews, provider interviews, those types of things. Perhaps they take a look at the data. It's a very simple situation and they just engage in provider education. That's best case scenario. Or they could go to prepayment audit or a payment suspension. And there's a variety of reasons why they may choose to go that route versus making a referral to an investigative agency. Perhaps the billing irregularities just don't amount to fraud. It's just something simple. It's an error that needs to be corrected. Or they're just seeing something that's unique in the data but doesn't really relate to like a fraud situation. Now, if it does rise to the level of a fraud situation, they may make a referral to an investigating agency. And of late, the Department of Justice has really paired up with CMS to collaborate on making those decisions as to when a referral should be made. So the Department of Justice may weigh in and say, you know, this case, this provider that the UPIC has been investigating is just not to the point of making a law enforcement referral. Maybe conduct additional beneficiary interviews, look at other sets of data, maybe go out and do a site visit or something along those lines before it comes over to the Department of Justice. Or simply the Department of Justice is just overwhelmed with cases and we're not taking that type of case. That's one reason they would make a referral. But there's a lot of strategic reasons that go into this as to whether they would take, you know, any one of these different tracks. And then on the other side, when we're talking about the investigators and the different agencies, so that's like HHS and, you know, FBI that we were talking about earlier, they have their own ability to review proactively billing data through their internally used programs. So HHS uses Palantir and the Department of Justice uses Acumen. And the Department of Justice's access to that data, as I mentioned earlier, the Healthcare Fraud Unit has those data analysts. They are using Acumen data to determine certain relationships within the data, to make a determination about whether to move forward with an investigation. And the Acumen data uses a statistical approach to reveal abnormal scenarios and live claims and provide provider enrollment data. So looking at both like the Medicare applications along with the billing data. Is there something about the two that, you know, are contradicting one another? We're seeing something in the data that is not borne out by the Medicare application, that sort of thing. This is usually on a 6-month delay because it takes some time for Medicare to, you know, finally adjudicate a lot of claims before they're able to go over. But even so, a 6-month delay, you know, when you're a prosecutor, you think, oh, 6 months is so long to get that data because you want it contemporaneous. But really, in the life of a federal investigation, that's pretty close in time to when the acts are actually occurring. Okay, and so let's look at what we're looking at in the data. So the prosecutors and investigators are looking for abnormal scenarios, what they call outliers in the data. So they use the billing data to tell a story about a provider's billing habits, and that could mean any number of things. But what they're looking for are things that are abnormal, things that are different from a provider compared to their peer group. They then take that billing data and they cross-reference it with open source data. So death records, corporate records, population data, you know, is there an ownership issue between two different entities? And we're seeing a lot of referrals going back and forth. That's something they could look at. And then with the Acumen data particularly, they're able to analyze these relationships further so they can see, you know, providers' relationships with referrals. One thing that is big is looking at home health agencies and being able to see is there a referral source from a particular physician to a certain home health agency? And then can they drill down into that data a little bit more and determine why that might be? They can look at provider patient populations. So, you know, thinking about like rural hospitals, they can examine, you know, whether beneficiaries are coming from a really long distance, or if it's a pain clinic, that's probably more of a likely scenario where beneficiaries may be coming from a long distance. Whether that if there's a rural hospital, whether they are providing more services than, say, an urban hospital would be. You know, that would be something that would be kind of a red flag. And then, like I mentioned, the comparison amongst provider types to determine outliers and specific billing habits. And then the general conclusions from the data, you know, what they're really looking for, what can they show from the data that they may need to do an investigation into further? And there's really, you know, a handful of types of things that they're looking at. They're looking at services not being rendered, is there some way in the data, and we'll go through an example in just a moment, but some way in the data to say, these services don't look like they're actually being provided, or are they not being provided in the way that they're being billed? That's a concern. And then looking at referral relationships, it could be improper. So concentrated referrals may mean an improper relationship, as we mentioned, like the home health example. Overutilization of certain treatments. That's again my rural hospital example where services are being provided at an abnormal rate for that location. And then we have this kind of idea of billing for more hours than there are in a day. And what that really means is looking at the codes that are being billed and kind of what we consider to be the appropriate time for those codes, either via CPT code descriptions or AMA descriptions, and whether or not those add up to more services than there are in a day. I'll tell you that is kind of we're going to go to an example in that in a little bit in one of the key TAMs. But that is a really tricky issue to move forward on because it just often doesn't bear out like you think it would. It looks very egregious on its face, but there's often a lot of different example or explanations for that. Now we're going to talk about a couple of these instances where data really does not tell the whole story. And when I say that, I don't mean that just as somebody who often looks into these cases and is kind of on the other side of responding to investigators' inquiries, but even the prosecutors take this kind of mentality to heart too, right? They know that the data is not always going to be the full story. It's just a starting point. And when I was a prosecutor, I used to lecture on that too, right? It's just a starting point to develop your investigation. It's not the whole story. You've really got to do traditional investigative techniques to really get to the bottom of an issue. So in this example, the provider is billing for a high number of injections with the diagnosis code, with the diagnosis of vitamin B deficiency. The billing data, however, shows that there's no claim submitted for vitamin B for the actual medication or the vitamin. So the suspicion then is going to be that the injection claims submitted for reimbursement are false because you'd expect to see actual claims for vitamin B along with the injection claims for the vitamin B where that diagnosis code has been attached. But upon further investigation through the review of patient files and witness interviews, agents learn that pain injections are actually what's being provided. And occasionally, of course, with a pain management physician, you may see pain injections and also vitamin B injections. But in this individual instance, what they're understanding is that pain injections are being provided and that the code used to bill for the injections was really a very broad injection code. And it's just the diagnosis code that was attached to that that's the problem. So an interview with the provider further shows that there's a communication problem with the biller, and that provider has maybe documented their attempts to correct these communication issues with the biller and to clear up past errors. And so then the conclusion is really that the biller erroneously added the incorrect diagnosis codes. Not that the services weren't being provided, it's they were billing with a diagnosis code that was inappropriate. All right, and then in looking at this one, another example of data not telling the whole story. So in reviewing 1 year of a hospital's billing data, investigators discover a large spike in hospital admissions in October. The number remains high for several months. Anytime there's a spike in billing data, a service that wasn't being provided before or a service that is being billed at a rate at which it wasn't previously being provided, that's going to be a red flag and it's going to trigger investigators to look further. So their suspicion then is that this is an overutilization of hospital services. But in taking a step back and looking at a larger set of data, so in reviewing the hospital's data for a 3-year period, the spike in hospital admissions occurs every October, lasts until April when the rate drops and then levels out until the next October. Well, obviously something curious is going on here. Further examination reveals that many of the patients are Medicare beneficiaries with out-of-state addresses. So, then thinking a little bit further into this, the investigators determined that the hospitals serve a snowbird population, right? That's those people who are Medicare beneficiaries, getting away from the cold weather, coming to a southern location for that time period from October to April. They are elderly, they are Medicare beneficiaries, and so they're going to have a higher rate of hospital admissions than another patient population. So investigators then are able to determine that that's really the cause for this increase in Medicare beneficiaries from October to April. It's not that there's a spike in billing causing overutilization.
And I'll jump in for this one. So this is our last sort of data does not tell the whole story slide. But in this example, pharmacy billing data shows an abnormally high number of opioid prescriptions compared to similarly sized pharmacies in the area. The suspicion here is that there's an improper relationship between the prescribing physician and the pharmacy, or sometimes what I've seen in our own investigations, a concern that the pharmacy is just sort of filling everything that comes across the desk and not performing due diligence. So they're filling prescriptions perhaps that other pharmacies are turning away. Here, when investigators, however, visit the location, they speak with pharmacy employees, they learn that the pharmacy is within sight of a level 1 hospital, and the patients are often receiving prescriptions from the hospital, traveling that short distance to fill them following discharge after surgery or other procedures. So in this instance, that outlier status is simply due to pharmacy location rather than any untoward action by the pharmacy.
Right, so as we mentioned, data doesn't tell the whole story. It's a starting point, not an ending point. And yet there have been some recent pushes in prosecutions to introduce data to show like an outlier status. And when I say outlier status, just to be clear, I'm talking about amongst peer providers, right? So something about the provider who is facing these charges, either civilly or criminally, who is different from their peers. And so there's been a recent push by the Department of Justice to utilize that in trial as evidence that the provider at trial committed the crime. The issue with this is, well, there's numerous issues, but the first issue with this is relevancy, because whether or not somebody, the trial is about whether somebody or a provider committed a certain act at a certain time. Whether somebody else, another provider who's in a similar peer group, did the same thing or did something different doesn't really bear on the fact that the provider at trial did or did not do the thing that they're accused of. So preliminarily, there's a relevance issue. But even beyond that, this is met with mixed results of judges and juries, because we want to know how a conclusion based on the data is formed, right? Are we just looking at some sort of statistical extrapolation, some sort of analysis that, says that provider X did, the thing that they've been accused of, or that they're different in some way from the others? And that requires a lot of expert testimony to really prove up how the data or how the conclusions were created. There's reliability issues, including both the method of arriving at the outlier status as well as the underlying data. And then finally, this is a large area for cross-examination, because as we just saw in those prior 3 examples, there's many ways to show that there's a different explanation for what's going on. And so demonstrating just that the data doesn't tell the whole story makes that kind of a difficult issue to move forward and to use kind of as your proof that somebody committed a crime or was charged with something civilly that they ultimately did or didn't do. But the bottom line is the Department of Justice and prosecutors are moving towards this. This is something that they've been trying to do for a while, and it just kind of remains to be seen if they're successful in this area. But those would be kind of my main thoughts on why it shouldn't be used. And then finally, and what I think is probably the most interesting part of this presentation, is data as a whistleblower. So we have been seeing, as we keep our eyes on a lot of False Claims Act filings and key TAMs that have been filed in recent times, there are a lot of instances where I think we put insurers using internal data mining to identify and report suspicious providers is one area, and then data analytics companies filing key TAMs based largely on the data with little actual investigation. So Erin's going to go through 2 examples, but when we think about a key TAM being filed, it needs an individual generally with personal knowledge of the facts that happened. That's usually somebody who's like a former employee or maybe an executive who saw something that was improper and went to an attorney, filed a lawsuit, brought it to the government's attention, and then it moves forward. But what we're seeing is certain circumstances where it is just a data analytics company that is looking at the same data that prosecutors have and is making their own conclusions based on what's happening without actually having somebody on the inside, like an inside witness, to tell the story of that. They're just using the data to move those cases forward. And that we've seen kind of mixed results with this, as Erin will go through.
Thanks. So this first example here, this is the first case where DOJ actually intervened, and one of these whistleblower False Claims Act cases against a healthcare organization that was based purely on an outside entity's statistical analysis of the data. I will note that the whistleblower in this case, IntegraMed Analytics, has tried the same whistleblower strategy in at least 3 other False Claims Act cases, all against hospitals, but DOJ declined to intervene in those other cases. So this is, obviously a pretty active analytics company with respect to these key TAMs. But in this case, IntegraMed Analytics brought a case against a skilled nursing facility owner. His name's Isaac Loffer, 10 of the facilities in the New York City suburbs, and one of the facility employees who happened to be the coordinator of rehabilitation services. And there, that key TAM alleged that they were, 1, keeping patients in that skilled facility longer than necessary, and 2, that they were really billing for the most expensive therapy level, pretty much across the board for all patients, regardless of their clinical needs or their ability to benefit. So DOJ, as I mentioned, did intervene in this, and in their 2021 complaint and intervention, they alleged that the facility was specifically directing staff to assign all or most of those Part A patients to what was the ultra, at the time, the reimbursement methodology was based on resource utilization groups. And they were pretty much always assigning patients to this ultra high therapy level, the highest level. And just for context, that equates to about 720 or more minutes per week of therapy versus low, which is about 45 minutes. So pretty significant difference. But in this case, the whistleblower complaint noted that its analytics specifically found that ultra high level of therapy tended to suddenly drop at the 60, 90, or 100-day mark, which corresponded with when the facility needed to justify that level of therapy to CMS, that they were administering that ultra high therapy billing 5.8 times the rate of other facilities. And this last point, which I think is particularly noteworthy, is that ultra high utilization level jumped significantly for 2 of the facilities after Loffer bought them in 2013. So they were able to look at, pre-acquisition and post-acquisition claims data and see that associated spike. In the DOJ complaint, they were alleging that the facility owner was monitoring performance, and if discharge numbers were too high, he would instruct that coordinator employee to extend the patient's stays, either by changing the discharge goals or overruling discharge decisions. And then just to kind of wrap up the data piece here, these allegations here were based entirely on IntegraMed's what they called unique algorithms and statistical processes that they claim allows them to identify false claims with specificity. So for this particular example, the proceedings are currently stayed through January 2024, but it's certainly noteworthy given IntegraMed's success so far. And then just our second example on this front. So here's a key TAM, and this one they were alleging that a home health agency was billing Medicare for too much excessive care plan oversight, or CPO services. In order to bill for those services for CPO, Medicare requires that physicians spend at least 30 minutes supervising a patient. And in this case, the relator was a company called Lincoln Analytics. It had no personal knowledge of the case, and it identified this issue through its analysis, and then it was able to interview 1 employee. Here they found that the data showed that the 2 highest billing physicians for these CPO services across all of Medicare in 2019 both worked for that same home health agency, and that one of their billings, if true, would amount to an impossibly high rate, 420 24-hour days in 2019. So to Adrienne's earlier point about more than the number of hours in a day. For this outcome, though, unlike the other case, DOJ declined to intervene, and this was ultimately dismissed. So Adrienne, before we leave this example, I wanted to kick it over to you. If you can maybe share your perspective on why you think DOJ intervened in the last example, but not this one.
Yeah, definitely. So in the first example, I noticed a couple of things when you're talking through the evidence that they have. They have a spike in services, right? That billing spike that they can see in the data. And then on top of that, you mentioned that someone was monitoring the discharges, right? And indicating when things needed to be changed, right? If records needed to be altered in some way. So obviously a witness told the relator that, right? They had to have a witness interview to shore that up because it's not just based on the data. So that's one reason. And then we look at the case that was declined, that the government declined to intervene in, and which was ultimately dismissed. They had one interview, which is pretty unusual for a relator qui tam. I mean, oftentimes there can be cases where it's just the relator, right? It's just one individual who has that personal knowledge, and that's the person that's interviewed, and it's based on that. But if you're looking at a case where it's built on data and you really only have a very limited amount of insider knowledge and it's just one interview, it's just not enough evidence to move forward. The other part of that is this billing for more hours than there are in the day. You know, when I was a prosecutor, I often had agents bring that to me as, look, this is so egregious, you know, it's more hours than there are in the day. Because that care plan oversight is a time-based code, that's where they get, you know, the conclusion that more hours are being billed. However, that's a very kind of what I would call squishy theory, you know, that a lot of holes can be poked in as to why it might not actually play out that way, that the time could actually be appropriately done. And so given just that, if that's the majority of the allegations, it's just not very strong really to move forward. And then on top of that, you only have one interview.
Yeah, absolutely. So, all right, so we were next going to go through some examples, and I will just mention these are extreme examples. They're huge outliers that started the investigation, and for all of these, DOJ was able to corroborate the evidence with other evidence, and it really moved forward throughout the process. So we oftentimes see much less egregious examples of this come up in internal investigations that are either addressed because of some of those explanations we talked about earlier, like distance or proximity to hospitals, things like that, or that are settled early in the process. So in this first case, this involved a multi-state network of pain clinics from 2007 to 2018. And here the doctors were essentially refusing to provide opioids to patients unless they agreed to receive unnecessary back injections. Specifically facet joint injections, which are among the highest reimbursed procedures. They were able to show that those injections were unnecessary, and that actually a lot of these ongoing injections caused patients to develop adverse conditions, including open holes in their backs. Evidence also showed that the clinics were essentially pill mills. They were frequented by those suffering from addiction and by drug dealers who were seeking high-dose opioids to sell. On the data side of this, the doctors only worked a few hours a week, and it looked like they found an email or something that it specifically said to stay under the radar of DEA. That's why they were limiting those hours. And yet they were among the highest prescribers of oxycodone in the state of Michigan. Those same doctors were also paid more for facet joint injections than any other medical clinic in the US. At a recent presentation, Jake Foster, who's the principal assistant chief with DOJ's criminal division, specifically pointed to this case, noting that the investigation progressed after data analysis produced this initial list of prescribers among the most prolific prescribers of opioids. And then they started to see relationships between different subjects who were on that list. So there were 5 physicians ultimately convicted in 2 trials, 18 others pled guilty, and 7 are awaiting sentencing. But this was a major coup for DOJ. This next case, this is a civil case filed against AmerisourceBergen, major drug distributor, and they were alleging that Amerisource failed to report at least hundreds of thousands of suspicious orders, that they were aware of significant red flags suggesting diversion, and that they were relying on deeply inadequate systems to monitor and identify suspicious orders from 2014 to 2022. And in this data, according to the complaint in 2017, the distributor filed fewer than 350 suspicious order monitoring reports, which was almost a 99% drop from the reports that it filed in 2014. And that same year, 2017, by comparison, its 2 major competitors filed 200,000 and 40,000 suspicious reports. So, fewer than 350, I think, really stuck out there. But I will just say that as far as data and, analytics go, this type of benchmarking that was involved in this case is very simple, but very effective. And here we see sort of 2 phenomenons. One is that big drop of AmerisourceBergen, the volume of reports, just that they were filing year to year, 99% in just 3 years drop, but then also benchmarking it against competitors. So, 200,000, 40,000, and 300 or so certainly sticks out on both fronts. Our third example, so this involves P-STIM devices. Medicare doesn't reimburse for P-STIM devices, and in these actions, this specific one was really primarily against those who were promoting the devices, but they found that the promoters were falsely representing to providers that P-STIM was reimbursable by Medicare, and that they should be using billing codes that were meant for surgically implanted neurostimulators that help manage chronic pain, and which happen to be reimbursed at thousands of dollars per procedure. In contrast, surgically implanted neurostimulators, and on the other hand, P-STIM devices can be applied in a few minutes. It's not surgical. It's in an office setting without anesthesia, and it can be done by someone with minimal training. So you're talking about very different products, very different resources involved in, providing patients with that service. And here in this case, DOJ is holding those who fraudulently marketed the devices as being responsible for the false claims that were later filed and paid by the healthcare plans. And they've also been pursuing cases against the providers themselves. I will mention that this case, the P-STIM cases, is an example of HHS, OIG, and DOJ using data analytics to identify new trends and fraudulent schemes, and then using subsequent analytics to identify and target similar instances. So here we can imagine that they started noticing a big uptick in billing for neurostimulators, looked into one or two providers, determined that it was actually P-STIM, and then looked for similar trends among providers across the nation to sort of further determine just how far the scheme had extended. For this example here, this is a false claims complaint, and I will just note the date. So this is a very recent complaint, and it involves COVID-19 testing, which I think is something we're going to really see an uptick on the investigation and data front. But this complaint specifically alleged that laboratories were offering these COVID-19 tests to nursing homes as a way to bill Medicare for a wide array of respiratory pathogen panels, RPP tests. And the complaint alleges that they were medically unnecessary. The beneficiaries had no symptoms of respiratory illness, and also that the specific panels were for uncommon pathogens. They also alleged that they were never ordered by physicians, and in at least hundreds of instances, they were never performed. And the data that kind of backed this up is interesting. So based on this proactive analysis of claims data, they noted that for at least 300 claims, the nasal test sample was supposedly collected from the beneficiary on a date after the beneficiary had died. So, earlier when Adrienne was talking about the types of data that they're looking at, dates of death, I think, are a pretty low-hanging fruit in terms of comparing those dates to the dates of services. And then this is our last example. So this example, DOJ has recently filed cases against Rite Aid Pharmacy, also Walmart Pharmacy. There's a lot of overlap between the two cases. And in both of them, it's clear that the case is really stemming from, really the substance of the complaint is stemming from analytics that were performed on pharmacy dispensing data that was obtained by subpoena during those preliminary investigations by DEA and DOJ. So in this Rite Aid case, a core allegation is that Rite Aid dispensed hundreds of thousands of prescriptions that DOJ alleges did not meet legal requirements, including repeated controlled substance fills with what they called obvious red flags. Those included Trinity combinations, so defined in their data set as an overlap, concurring use of a benzo, an opioid, and a muscle relaxer, excessive quantities of opioids, early fills, and this one's interesting because in the Rite Aid case, they define that to mean any fill of a controlled substance more than 48 hours, filled more than 48 hours before the prior fill would have expired, or even the patient would have run out of it if used as directed. Some of the other red flags were patients with multiple prescribers or those who were on a controlled substance prescription for more than 12 weeks. And that's just an example. There were a lot that they were pulling out there. But for each of those flags, it's apparent from the complaint that DOJ ran specific algorithms across all of the dispensing data to identify and quantify those responsive prescriptions. Just before I hand it back off to Adrienne, I'll mention that Walmart and Rite are really disputing this approach, that DOJ and DEA can allege that prescriptions that meet certain algorithms are per se violations of the Controlled Substances Act. That they can do so without a case-by-case review of like the dispensing data and other information. So it's an open question, an open issue on whether this data can be used in this way to really generate the violation list and the penalties. But either way, this approach of running analytics across subpoena data will certainly remain and is very common.
Yeah, just one thing on the cases that you covered, in the opioid prescription area, it does seem like data analytics is really the driving factor in a lot of those cases. And when we think about, I was talking about the healthcare fraud unit earlier being created, one of the things that they created a little bit later in time after the initial unit opened was an opioid strike force in order to go after those cases, because not only do they now have billing data, they also have PDMP data. And the two together, and of course, beneficiary death records, right? And the three really together is a lot more solid than just looking at the Medicare data for like a traditional provider outside the area of drug diversion. So anyway, now that we've gone through some case examples, kind of explained how the data is used, you might be wondering, what can I do in my organization to not be on that red flag list and to not be somebody who has to respond to investigators' inquiries? So what we would recommend first is proactively review internal billing data to determine areas of concern for investigators. So, say you're the type of provider, I know it's probably not likely for this group because we mostly have folks who are associated with hospitals, but if you were a pharmacy, you'd want to look through those red flags and make sure that your pharmacy is not committing the same types of, acts that we get on investigators' radar just by looking at your own internal billing data. So you've got access to the data the same way the agents do. You can proactively look at that and see if you're finding any specific areas for concern. One thing you can do is review shifts in trends, such as sudden upticks in certain services. Is that due to an internal problem or a change in services available? Of course, when we were in the PHE, we definitely saw a huge rise in telehealth visits. Obviously, that has a reasonable explanation that pretty much everybody's aware of. But is there something else similar in your organization, and can you attribute it to maybe a change in services or some other external force that has caused that? And then, to the extent you can compare your own internal billing data amongst similar providers using publicly available data. So CMS releases Medicare data. I'm not sure exactly at what delay it's at. However, they do release release data in order to look at kind of what services are being utilized, and you could use that to think about where your organization fits amongst your peers. Where there are troubling scenarios that are rising, document the unique basis for treatment in the patient file. We always recommend that, as well as the benefit to the patient receiving the treatment, so that you can substantiate why, maybe there's a certain service that is being provided to a new group of beneficiaries, and you're documenting why there's a change in services, why it's particular and unique to those beneficiaries. And then also note similarities or differences in practices to demonstrate explanation for a perceived outlier. This one's a little bit tricky because where do you document those things, right? When you're talking about particular services for individual beneficiaries, you can document in the patient file. Is there some other place in your organization where you can note, like taking that rural hospital situation, you're not rural hospital, but the hospital situation with the snowbirds that we mentioned earlier, could they have documented, internally, okay, look guys, we're gonna need to have an increase in staff because we know that from October to April, we're gonna have an influx of hospital admissions that we wouldn't normally see. Something along those lines to show why things in the data may not be as they seem. All right, and then utilizing the data to determine areas of need. So and this is another area where documentation is appropriate, right? Additional training. If you have certain providers within your organization that could use additional training, or coders or billers that need that additional training. You can document that, the steps that have been taken once an outlier issue has been determined, where additional documentation could help, and where there could be a process change in order to make sure that everything is kind of checking out the way that you would hope it would, so that you're proactively putting in place measures to solve those issues. Of course, like I said before, document the efforts to improve these areas of concern. Another thing to do is analyze denied claims. I don't know how frequently this is done on a routine basis. I mean, obviously denied claims are an area for concern from a reimbursement perspective, but really if there's something you're seeing in the denied claims that could tell about trends, that maybe there's a need for more contact with the billers, better explanation, better communication with billers in order to eliminate some of those denied claims, or is there something that you're seeing that's just a trend that needs to be addressed in another way? And then document all interactions with oversight agencies. Anytime you contact the UPIC or any other Medicare contractor, or even private payers, you should be documenting those interactions. To the extent information is given to you about why or why not something has been denied, or why if there's additional guidance, if there's provider education, you should be documenting that and your understanding of the information you're receiving. And then finally, do not assume that audits and requests for patient records are routine. While the UPICs do this frequently, this is part of their job, right? They are to investigate billing irregularities. When it comes to the requests that you get for patient records, or the call from the program integrity coordinator, you need to take that seriously. Don't assume it's routine. Treat it as if it is the worst case scenario, so you can get ahead of any issues that may come up. I can't tell you how many times we have assisted providers who went through maybe 3 or 4 production of patient records in response to an audit, and then contacted us after. Not only does that make it difficult to kind of get ahead of the problem because you're now behind, with all the records that have already been provided, but it's just something that experienced counsel can guide you through. It really isn't something you should have to take on by your own, on your own. And then, like I mentioned, contact experienced healthcare billing and reimbursement counsel is what you need. I do government investigations, and I definitely handle billing and reimbursement issues, but there are also counsel throughout the nation that are very specifically focused on those areas. And you should do that likely upon your first contact with an oversight agency.
We have a number of those folks here at the firm.
Yes, we have a number of those folks. Yeah, we have a number of those folks at Polsinelli, definitely in our healthcare group, that do just really any kind of issue you could think of. But you want to do that upon your first contact with an oversight agency, a Medicare contractor, or Medicaid fraud control unit, no matter the level. Whether it seems serious or doesn't seem serious, you need to contact counsel. And then, of course, one of the things that I do in my practice a lot is I try to intervene early in the matter to determine the scope and focus, right? Because as a provider, if you are receiving, a request for patient records, or you're learning that maybe some of your former employees are being talked to by investigators, you really only have one slice of the information. It's just one tiny piece, and it's important to have counsel to be able to contact investigators and understand, basically how big is the investigation? Is this a small issue? Who does it deal with? Sometimes that information can be gleaned early on, and it really helps respond to the investigation, minimize the impact and disruption to your organization. And then finally, putting in place an effective compliance plan to reduce future audits is also something counsel can help with. And an effective data-driven compliance plan would include the development of formal compliance policies to conduct annual outlier hospital reviews for proceduralists, and then subsequent review of sample cases to ensure there are no medical necessity concerns. Certainly at Polsinelli, we've assisted many organizations in putting in place these types of compliance plans. And the benefit of that is that the subsequent review for the outliers that have been, or the issues that have been noticed in the initial development and the initial review of data, those can be addressed under the attorney-client privilege. And that, I think, is just very helpful, not only to figuring out what's going on, but also to putting in place measures to solve those issues and keep it protected under the privilege. Anything else, Erin?
No, that's it. We're happy to help with any of these things if they arise.
Yeah, definitely.
All right, thank you, Adrienne, and thank you, Erin. That was a great presentation, and I'd like to tell the attendees this is a good opportunity to ask the experts. If you have questions, type them into the question box. And we have one here from Kathy. What causes the CMS to institute a prepayment audit or payment suspension?
Mm-hmm. Yeah, definitely. So two different things. A payment suspension is pretty severe remedy, and so there could be a variety of things that cause them to institute that. One thing that we often see is quote unquote credible allegations of fraud. Now that doesn't mean that there is fraud, and it doesn't mean that the fraud is defined specifically, but that would be one thing that would require, or I guess initiate, prepayment suspension in order to kind of cut off funds going to the provider while the UPIC has an opportunity to investigate further.
Okay, we got a question here from David. How are referrals made to the Department of Justice?
Yeah, so referrals are made, well, for a variety of ways. So like if we're talking about a data-driven investigation, a referral is going to be made either through, well, just back up just a moment. So it depends on kind of where the information is coming from. So if it's coming from the data analyst within the healthcare fraud unit, they're literally walking down the hall and making that referral and saying, here's what I found. Do you want to take a look further? Let's get some agents assigned. Let's get it investigated. If it's coming from the UPIC or from the Center for Medicare and Medicaid Services, it could be through that process where there's collaboration with the Department of Justice. It could be that a prepayment audit was put in place, it was ineffective. A payment suspension has been put in place, there's still issues that can't be resolved. And then those kind of credible allegations of fraud make their way over to the Department of Justice and they investigate further.
Okay, here's a question that came from Mary earlier. What helps determine when these types of data findings are used to prosecute criminally versus civilly?
Sure. So there's a lot of factors that go into that. And Erin really works more in the civil realm and I work more in the criminal realm. So I'll just talk briefly about what would make a case go criminal, and maybe Erin can talk about what would make a case go civil, or kind of what she's seen in her investigations. A criminal case, the number one thing that prosecutors have to prove is intent to defraud. And that's a high bar, right? You have to have actual, bad intent to steal money or something along those lines. It's just a much higher bar. And then, of course, when you get through the process and you end at a trial, you've got to prove those allegations beyond a reasonable doubt. So prosecutors are looking for something particularly egregious to take it criminal. Something along the lines of one of the examples Erin mentioned, an owner of the company inserting themselves into medical decision making and directing providers to do a certain thing versus another kind of treatment option. That would be something that usually you would see in a criminal situation. Services not rendered, just really egregious open cases of fraud. We're not talking, middle of the line, kind of could go either way types of cases. It's got to be pretty egregious to go criminal.
I get the easy answer because my side of things is typically it's not as egregious as criminal, right? So it'll tend to default the civil side if you don't have some of those really bad facts in the case. But I will also mention too, in the way that we often interact with these cases at the firm is it's not yet really, it's an investigation. So it starts, we get a CID, we have some discussions with the AUSAs. Oftentimes we work to try to explain why there's no there, and we're successful with that for many clients. And sometimes there's more meetings and discussions about, opportunities for clients, for health systems to improve and do something better. We can get a CIA or something like that in place and really avoid anything ever going to court. But it's essentially, if it's not criminal, then they're oftentimes going to go the other route.
And I would just say from an attorney's perspective too, whether you have an idea if it's going to be civil or criminal, we always prepare for the worst and hope for the best, right? So we are always attacking the problem as if it is kind of a worst case scenario in order to make sure that, we're getting ahead of the problem as early as we can. And I would say sometimes the civil issues, can be more challenging just because they can be gray areas. Sometimes there's a reasonable explanation and it takes some time and effort to present that position to, whatever prosecuting entity is running with the matter. You know, on the criminal side, it's just really a different situation. And most of the cases we see are really, you know, they're investigations, so they haven't gone civil or criminal, or they're in the civil realm.
Okay, I got a question here from Rick. Thank you, Rick. Are benchmarking reports on public claims data that compare utilization ratios useful, such as ratio of complex pneumonia to simple pneumonia?
Yes, they are. They're useful. I mean, I think that they don't tell the whole story, right? So if you're showing up with more complex and simple, and you have a really sick patient population, like there's not always an issue, but that's the exact type of thing that we advise compliance programs to be thinking about from a claims for billing perspective. And then just also the publicly available data can be tremendously useful in the same way that these analytics companies are able to pull out outliers themselves. Health systems can be doing the same and really keeping an eye on things where they are respective to their peer, you know, other hospitals in the nation. And then also just their own internal analysis. That last slide that Adrienne presented about the hospital compliance programs and looking at your like top 10% of proceduralists, we help hospitals develop those programs frequently, and they can be incredibly effective because it shows that you're, A, you can get ahead of any issues that might exist, but B, if you do end up getting a call from an investigator, you have some really positive things you've been doing internally to try to avoid the issues that they're concerned about.
Okay, I have a question here from Kenneth. Would a billing company that operates internationally and is unaware of any malpractice at the facility also undergo an audit?
A billing entity that it probably, well, I don't know that the audit would be an appropriate term for that. Could they undergo an investigation? Sure. I know that we have had circumstances where, well, when I was a prosecutor, honestly, where there were billing agencies that were really the target of the investigation. You know, maybe there were other issues happening, or maybe target is not the right word. Maybe it's a provider along with a billing agency. So we've definitely seen an investigation kind of launched into that side of it as well. I think it's really important that providers and billing agencies really collaborate as much as possible and communicate freely, because you know, that's the issue. If something comes up that the provider hasn't conveyed to the billing agency, or the billing agency has a misunderstanding about some sort of service that is being provided by the provider, that clear communication is important. But yeah, we have seen some investigations related specifically to billing agencies.
Okay, we got a final question here. It's from Amir. Once data analysis has caused an investigation, how should providers respond?
Proactively. So, you know, it depends on how you learn that investigation has started. Usually that is either through a phone call directly from the investigator. So probably Medicare at that point, right? They're more likely to be the ones that would reach out directly to a provider and say, we need these patient files because, you know, we've got an issue that we're looking at. We want to determine whether there really is proof in the patient files for the medical necessity of the charges that are billed. The provider needs to reach out to counsel immediately. Counsel should be a buffer between you and the oversight agencies. It doesn't mean, people always think this, that you know, somehow you're implicating yourself in having done something wrong. That is not the case. And I would say investigators, prosecutors, no one thinks that that is a problem, that hiring counsel to facilitate your relationship with oversight agencies is expected. It really truly is, and it's really just the best way to protect your organization and also move things along, right? You want that investigation to be resolved, and so you've got to have some way to proactively move it through the process, and counsel can help with that.
Okay, what a great presentation. Thank you, Adrienne, and thank you, Erin. Just some great information. I would also like to thank all of the attendees who participated today. It was a great turnout. And those are some excellent questions, so thank you. I would like the attendees to know we recorded the presentation. I'm going to post it online tomorrow, and everyone who is registered will be sent a link. And I'm also going to send out today's presentation to everyone who registered. But I'm going to hand it off finally here to Adrienne and Erin. Do you have any closing comments?
Just like to thank you so much for the opportunity to speak to the DFW Hospital Council. You know, Polsinelli's been involved with the council for a little while now. It's been a really positive relationship, and we just always appreciate the opportunity.
Thank you.
Thank you both. We're now going to end the webinar, and thanks to everyone.